Who recognizes this sound? Please raise your hand. I knew I wasn't the only person over 50 in the room, so it's great to be among you. And what a great conference we've had so far. I mean, yesterday couldn't start it better with a really positive Peter Leiden bringing it out for innovation, for everything, for a new age. And I was particularly, as a lawyer, I was particularly struck by the fact that not only translators will be made abundant by AI, but also the lawyers. So here I am, a dinosaur, speaking to you as one of the last speakers of this conference. Michiel, this is very positively scheduled, bringing a lawyer in just before lunch. We'll see how we will be doing. So this sound, I mean, how did it make you feel, the dial-up internet sound of 1996? It's a positive feeling, eh? It's a feeling of innovation. It's a feeling of being able to do things. And Jeroen, when we were just talking about regulations and trusts and the way he trusted people, that was very much the way we were thinking in those days. And of course, the question that we need to answer now, is AI the dial-up of the internet moment? Where will we go in regulation terms? And as a person over 50, I can say I'm quite positive as a person. I mean, I realize I'm kind of over the hill, but over the hill is also going down, so it's an easy tread, so I'm kind of happy with that. But I must tell you, this will not end well. How we are going to regulate the internet, artificial intelligence. This is me in 2001. I was young at the time. You can see that, no gray hairs. In my new office, I shared that office with the internet provider Access for All. That was one of the first internet providers in the Netherlands. Scarcity in abundance, a clean desk policy. Michiel, it'll appeal to you. And I was full of hope. And basically, hopefulness was what we were presenting to each other in those days. In 1996, John Perry Barlow, he was a songwriter for a rock group in the United States, the Grateful Dead. Anybody know John Perry Barlow? Show of hands, quite a few people that know of him. And he wrote the Declaration of the Independence of Cyberspace. So cyberspace, apparently Al Gore coined the term cyberspace, or the electronic superhighway, as it was called also in those days. And his Declaration of the Independence was, governments of the industrial world, leave us alone. You have no business here. You need not be here. There are no rules that are governing us. This is a lawless place. So we have the offline world and we have the online world, and online, you should leave us alone. And strange as it may sound now, in 2023, that was actually what we did. That was actually the rule that we applied to the internet. So these are the 26 words that kind of created the internet from a regulatory perspective. Section 230 of the Communications Decency Act in the United States, but similar laws were implemented in different countries, also in the European Union. And basically, the law said, if you provide a platform for others to speak on, you yourself are not the speaker. As a consequence, you yourself are not violating copyright law. So this was the most important piece of legislation that created all the innovation on the internet. And what helped is that the first cases that were brought under these new laws were brought by organizations that weren't necessarily kind at heart. So the first biggest internet case that came was a Scientology case. A Scientology case against Access for All, the internet provider I had office with, and against Karin Spijnk, who wrote articles as a columnist for a big Dutch newspaper. And Karin Spijnk had published the Bible of the Scientology Church. Now, basically, publishing the Bible of the Scientology Church amounted to copyright infringement. And the big question was, is Access for All also, as a platform provider, also violating copyright law? The court applied the new rules and eventually said, no, Access for All is not infringing copyright law. And this brought us innovation, it brought us Google, it brought us the age of social media. And also we need to be mindful of the fact that in those days there was a general feeling that technology was doing good, that companies like Google were not evil, were helping us, were creating innovation. And at the same time, there was this culture of piracy, and this is a Steve Jobs quote, that piracy is good, and that it's good to break things. If you're not breaking things, you're not creating anything. And this all changed in 2014, 2015. And this is an important moment in time if we look back. With the Cambridge Analytica scandal, by which 87 million Facebook profiles were used to target Facebook users by a data management platform called Cambridge Analytica, we understood what the power of big tech was and how it could be used in an intransparent way, and also, importantly, how it could be used to influence politics. It got us, according to some, it gave us Donald Trump. According to some, it gave us Brexit. So from a legislative approach, from a regulatory approach, this was an epical moment. This was a really important moment. And from that moment in time, the EU started to regulate big tech. Also in the US, but especially in the EU, we started to regulate big tech. Since that moment in time, all the rules that have been implemented have been anti-big tech to a large degree. In 2018, of course, we got the GDPR, regulating big tech, but also in 2019, we got a copyright directive, also regulating big tech. And the rule that was implemented in 2019 basically took away the earlier safe harbor, the rule under which companies like YouTube were not violating copyright law if somebody else was posting something online. So these rules, these Article 17 rules, are specifically focused against big tech platforms, sometimes called the YouTube tax, taxing YouTube for their conduct. They're trying to solve a value gap, trying to give additional incomes to artists, creators. And the question, of course, was, is this an existential threat to YouTube? And it hasn't been so far, but I must also say the cases haven't been this issue hasn't been really tested so far. But the idea that anyone who violates copyright on YouTube will bring, or possibly bring, an action against YouTube itself is a kind of powerful tool. It was also 2018 that Macron gave his famous interview to Wired, in which he laid down the route for AI in Europe. And it was the French that first saw that it was important that we'd have ethical standards, that we'd have regulation in AI. And now, what we've been seeing the last year, yeah, frankly, as a lawyer, it's incredible to see what we've been seeing so far. I mean, the amount of cases that have been coming up against AI manufacturers, it's just mind-blowing. I mean, it's an avalanche of cases. There's not an AI manufacturer, producer that isn't hit by big legislation, and it can, or by big cases. And it can be class actions, direct actions, doesn't really matter. I mean, supervisory authorities, they're all over the place. And it's all about, on the one hand, what comes out of the machine, but as we heard this morning, it's also very much about the data that goes into the machine. What is going into the machine? And as we've heard, the data may be the problem. The training models may be the problem. If ChatGPT and other AI manufacturers are all based on what is already out there, it's all based on copyrighted content. And frankly, from a legal perspective, this is a very easy case. This is not a very difficult case. And again, they still have to come to rulings and the judgments have to come, but it's clearly that there are infringements going on. We saw an example this morning also of Getty images being used by Stable Diffusion. There's a big case going on from Getty against Stable Diffusion, and this is one of the examples that they submitted to the court. You can see how the watermark has been taken away from the original picture. And you can see the likelihood in the pictures itself. Now, of course, at the end of the day, a lot what comes out of the machine is completely new, and it's style, which is unprotected so far under copyright law, so there's no problem with that. However, clearly, what went into the machine was a Getty image. And the fact that this was training material for the machine is going to be a big, big, big issue. And we're talking about this, regulators are talking about this worldwide, how we're going to solve this, how we're going to tackle this, what we're going to do about it. And of course, we know that the European Union is working on the AI Act currently. Hopefully, it'll be adopted by the end of the year, but the story is that it'll be delayed, and it may not make it until the end of the year. But if it does, it'll still require some time to actually be implemented to actually go into effect in the different countries. And it's important to realize that the AI Act is basically a safety regulation. It's like regulating toys, but then it's safety regulation on steroids, because it has the human rights angle. It added the human rights angle to it. So the fundamental rights angle is added to the regulation. It requires companies, AI companies, to do a lot of the work themselves. And in that regard, it's similar to the GDPR. It's a lot of self-assessment tools, and it'll be hefty fines that will be governing the AI Act also. Now, one of the little rules that has been implemented within the AI Act as an amendment in Parliament is a section to Article 22B. And this is where the copyright industry got its way. Because there's a requirement in the AI Act, as it is now, to make transparent the training models you've been using so far. So going back to the Getty image, it will be a requirement for AI companies to inform us what they've been using as training models. And the difficulty here, of course, is that, I mean, who can argue against transparency? Transparency is an important requirement under the GDPR, and everybody's in favor of transparency. So I'm kind of convinced that this will eventually be adopted, and then it's just guessing where they'll go. And I'm sure we'll see a floodgate of new cases coming up. This is a chart on which a PhD student has shown which aspects of the AI Act are the different AI companies already abide to. And you can see copyrighted data over there. The third one, it's not something that they're abiding to currently. So this is going to be a thing. And where is this going? Well, we kind of know from history where this is going. When the VCR, the Betamax VCR, was introduced in the 80s, the film industry started to litigate immediately. You have Mr. Jack Valenti here over on the right, who said the VCR is to the American film industry like the woman Home Alone, or the Boston Strangler to the woman Home Alone. It was killing the business, basically, he was saying. Now, we know that eventually that didn't happen, but we also know that they started litigation. And we also know from experience, from my personal experience, that during the peer-to-peer wars, we've seen a lot of litigation going on against these companies. And they prevailed to a certain extent. They settled their cases, they adapted their business models. We had Spotify come along, who actually obtained the rights to the music industry's repertoire. But I don't know whether you've seen this fantastic Netflix series, the playlist already. It's a Swedish series. Anders, this is specifically for you and the other Swedish people in the room. It's a really good series. But it's striking to see what Daniel Ek had to go through to obtain licenses. Because we need to remember, copyright is an exclusive right. So if we want to solve this issue of AI being built on copyrighted works, the AI manufacturers have to obtain permission from all the rights holders worldwide. It's kind of difficult. You can do it possibly in relation to music only, or in relation to film only, but all the content worldwide. We've heard this morning that ChatGPT uses Instagram to a certain extent. Hence the salmon model that we saw, the salmon picture, going upstream. Now, who's going to clear the rights of all the Instagram users? And it only requires one Instagram user to start litigation. So it's an issue here. And the clearing of rights issue was only solved with Spotify by having the record companies become owners of the company itself. The French have just come up with a new proposal saying that anything that comes out of generative AI should be perceived to have been created by the combination of all the authors of the training data. So, I mean, we have this problem in film that we have a multitude of creators. So how are we going to solve this problem? I mean, how are we going to settle the rights of all the data that went into the machine? It's kind of impossible. We need to remember that copyright was invented as a right to control what went out of the copying machine, the Gutenberg printing press. So that's where it originated. And now again, we're seeing reproductions being made for IA models. And specifically, those reproductions that went into the machine will lead to infringement cases. And how much needs to go in? Well, only 11 words suffice. So if you copy 11 words, you're already infringing. So there's no question about it whether these companies are infringing or not. Now, YouTube came up with a content ID system at some moment in time. Basically, a system by which it could recognize the content within or within its platform. It evolved into a filtering mechanism. Some people are already saying, well, this is what we need. We need to implement a similar system in relation to AI. But it's going to be really difficult what to do with all the learning programs. Now, of course, I've talked a lot about copyright and the issues of the training data going in. There are a lot of legal issues I didn't touch upon. ChatGPT is able to explain to you which other legal issues are important in relation to generative AI. It's interesting to note that the issue I've raised here today is not mentioned on the list. So it's interesting to note that ChatGPT so far doesn't realize that this is probably the biggest life-threatening issue surrounding it. So hopefully, Peter, there will be still some future for lawyers. If you look at the introduction of BART in the European Union, a lot of people didn't really understand why was it delayed. Why was it delayed? It was everywhere except in the European Union. And the rumor has it that Google decided to delay the introduction of BART because of the GDPR. So we need to realize that our regulation, what we are implementing here in Europe, in a different era, strikingly different era, a more restrictive era, it may not end well. And we may end up with a climate here in Europe that is very restrictive in relation to AI. And we know that if we here in Europe will be governing the AI, with our ethics, with our AI Act, with our rules, others will not. And the question is it possible to govern AI in Europe only? And how will the people on different continents will govern AI, and where will that lead us? I know one thing, it's a lawyer's paradise. Thank you.